We have Judge Nicolatos with us today. We're very pleased. He's an old friend and a dear friend, and very knowledgeable in this on this issue that we're dealing today, namely how does corruption affect a democratic regime like Cyprus, and indeed a small country, a small society, and where essentially everyone more or less knows everybody, and there are tendencies towards a more clientelistic political culture, let's say. Judge, welcome.
Thank you very much, dear friend.
Can we start? What is the definition, the legal definition of corruption in Cyprus?
Okay, I do not have the penal code with me, but in plain words, I would say that corruption is the act or the omission by somebody mainly in authority in breach of his or her legal obligations and with the purpose of gaining an advantage for the person who makes the illegal act or omission. This, I think, is what the ordinary person understands by corruption, and I'm speaking mainly about persons in authority, persons who have executive or legislative or judicial power, or civil servants, people, that is, who make important decisions that they affect the interests of many others.
What would you say are the sources of corruption in Cyprus? Are they culturally based? Are they, do most people share this view that corruption is bad, or is there a throwback into a more Oriental mentality which is prevalent in the region, where nothing gets done unless you pay somebody in authority off?
I think that the society in Cyprus was brought up respecting the rule of law and the independence of the judiciary. This is a legacy from British colonial times, I would say, and people are upset when they see that in our days there is corruption, or I would say a higher degree of corruption than what we had been used in the past. I wouldn't say that it's part of the culture of the Cypriots, but of course the sources of corruption, in my opinion, are first the greediness of the persons, especially persons in authority, that they want to make money illegally by not performing their duties properly. And the second source, I would say, is that there should be more checks, mainly of the people in authority, more investigations of possible corruption cases, that they should lead to prosecutions, more prosecutions of corrupt people in authority, and eventually they should lead to convictions by the courts. As you know, the Director of Public Prosecutions in Cyprus is the Attorney General. The Attorney General is both the legal advisor to the government and the Director of Public Prosecutions, which means he has the authority to decide who will be investigated, who will be charged, who will be prosecuted, and who will be brought before the courts. So the position of the Attorney General is extremely important in the fight against corruption. And I would say that the present Attorney General, who is a very capable and honest person, I'm sure that he will do his best to fight corruption.
You headed a committee last year that looked into some of the major problems with what people colloquially call golden passports. There was a program in Cyprus by which people were entitled to receive citizenship after investment. I've seen your reports. They're very long and very detailed. I'd like your just a comment. What was it really the program at fault? In other words, the legal framework was flawed. Was there a bad application of that legal format? Was there abuse? I mean, all of these things. I'm sure the answer is all of these things.
Yes, I would say that all of these things were to blame. The legal framework, I think, was too broad, and it was leaving openings for abuse. I think the way it was applied, it was also wrong in many respects, and there was abuse. First of all, we have found that about 54% of the citizenships granted by exception to foreign businessmen and investors was done ultra vires, which means outside the framework of the law. For example, the law was permitting the granting of Cypriot citizenship by exception to foreign investors and businessmen, but there was no provision that the members of the family of the investor or the businessman could also have Cypriot nationality by exception. And it seems that the councils of ministers from 2007 that we started investigating until 2020, they have done this mistake that they thought that they could grant Cypriot citizenship by exception to the members of the families of these persons, these businessmen. So this was a big part of the problem. I think there was also abuse in some cases, in that the criteria applicable at the crucial time were not applied, and other criteria that they were applicable in different times were applied. We have found that about 85 cases of the thousands that thousands of cases of granting Cypriot citizenship by exception, they should be investigated by the Attorney General, by the police, and eventually the decision belongs to the Attorney General. The Attorney General has said that these are not easy cases, they are time consuming, they need evidence from abroad, and it will take time, but he has stated many times that the law office of the Republic, as well as the appropriate department of the police, are working on these 85 cases that we have suggested that should be scrutinized and investigated very thoroughly, because in our opinion, in the Commission of Inquiry's opinion, there could be criminal offenses behind these cases.
What about the service providers in Cyprus? They're here, and there doesn't seem, at least, has there been a move against these service providers? Because if anybody abused the law, it was the service providers.
Yes, the service providers, yes. We have made comments about the service providers, advocates, accountants, banks, and others. And we have invited the disciplinary organs of these people to take action. For the advocates, the disciplinary body is the Cyprus Bar Association. There is a similar body for the accountants, and for the banks, it is the Central Bank of Cyprus. And we have invited them to investigate and scrutinize some cases that they seem to us that they were cases involving failure of the service providers to do their duty according to the law, or at least according to the etiquette of the profession.
Does your report provide for a follow-up or a supervision of what actions you suggest will take? In other words, will you review the situation in a year or 2 years or 5 years?
No, there is nothing of the sort. Our term was a fixed term of 3 months that was renewed for another 6 months, another 2 terms by the Attorney General. But our mandate came to an end on the 6th of June last year. So from that time, the Commission of Inquiry does not have any powers. It is functus officio, and it is up to the Attorney General to follow it up. At any rate, it is the Attorney General who has appointed the President and the members of the Commission of Inquiry. Many people do not understand the difference of being appointed by an independent organ like the Attorney General, or being appointed by the government or the executive power. But there is an important difference, and our Commission of Inquiry was not accountable in any way to the government. It just had to do its duty in accordance with the mandate of the Attorney General.
So you were more in an advisory capacity, not in a determinable. I mean, your findings were not determination of law, and therefore they should be actionable. They were They were an advisory opinion to the Attorney General.
I would say it was more of a fact-finding commission. We had to examine various cases, all these cases actually from 2007 until 2020, and our mission was to write down the relevant facts and of course our suggestions, but it was not a court of law. We didn't have any prosecutorial powers. We just had to state the facts and then give our report, which was very lengthy, to the Attorney General. The follow-up is done by the Law Office of the Republic, and in particular the Attorney General and the Deputy Attorney General.
Can I turn your attention to another point which may be of great significance, and you may be able to answer this in your capacity as the President of the Supreme Court, in which you had acted in many cases as a constitutional court.
Yes.
This is a constitutional question.
Yes.
In Cyprus, the Council of Ministers is the supreme legal authority. Is it not?
I would say the Council of Ministers is the organ exercising executive power. The President of the Republic presides over the Council of Ministers, but he does not have a vote. So the decisions of the Council of Ministers are taken by the members of the Council of Ministers.
But my question is a bit more specific.
Yes.
You mentioned in the beginning of our talk that the legal framework had gaps and which were interpreted in a particular way by the various councils of ministers for many years.
Yes.
I would submit to you that they have the power to do so. And therefore, you can't really blame the legal framework at the end of the day. You have to blame, and I mean blame with in a very cautious way. I'm not suggesting that you blamed anybody, but there is blame to be assigned if blame does exist on a political level. Because
Yes.
the decisions of the Council of Ministers are made on a political level. Now,
Yes.
if there is an intention to grant citizenship to a particular person,
Yes.
they can do that.
Yes. Okay. But
Whatever the law says.
no.
Well, they can bring as a cause national security. They can do things for national security, for the good of the republic, even if it's strictly not in the law. Is that not the case?
Okay. I say that this our question that we dealt with was the granting of Cypriot citizenship to foreign businessmen and investors by exception. The particular law was mentioning the conditions and the terms under which this Cypriot nationality could be granted according to the law. The Council of Ministers could not infringe the law, it could not bypass the law, and it could not do whatever it wanted in contravention of the law.
But if the law was silent, Judge, if the law was silent, they could fill in the gaps, which they did.
Yes, but in this case, the law was not silent. The law was speaking about the foreign investors and businessmen. If they wanted to grant Cypriot nationality to the members of the family, they should have prepared a bill, send it to Parliament, and ask Parliament to amend the law so that it would give them the power to grant Cypriot nationality to the members of the families of the investors or to whoever they wanted. Also, there was another section of the law that they did not make use of, giving authority to the Council of Ministers to grant Cypriot nationality on merit. This is a different thing. The Council of Ministers could grant Cypriot nationality, for example, to a very good friend of Cyprus, who is an important, an important scientist in the United States of America.
But there's no definition of such merit. There is no written down definition of what such merit is. It's up to the discretion of the Council of Ministers.
Yes, but if they were using that, section to grant Cypriot citizenship on merit, then they should give a different reasoning and say why they grant Cypriot citizenship on merit. And in this case, they wouldn't be accountable to anyone, because probably such a granting of nationality on merit is an acte de gouvernement, which is not subject to judicial review.
Right.
But in this case, they did not say that they were doing it on merit and as an act of government, but they gave reasoning which was applicable to the particular law of granting nationality by exception to businessmen and investors.
What was the argumentation in support of granting citizenship to corporate executives in mass?
Yes.
In the case of an investment by a corporation?
Yes. Unfortunately, this was the other. This was the other problem. The one, as I said, was the members of the family, and the other was the executives of the companies. There was no provision in the law for granting Cypriot nationality by exception to the executives of the companies, but probably they wanted to facilitate them to stay in Cyprus, or I don't know what other reasons existed. And they did it, but again, it was ultra vires. Another illegality in inverted commas, in the sense that the councils of ministers acted ultra vires outside the framework of the law, was the granting of Cypriot nationality to executives of companies that they were investing in Cyprus or doing business in Cyprus. This was not permitted, but it was done in various cases, and we have mentioned in our report that this was ultra-virus.
Usually, as a method of fighting corruption in the political sphere, there is a methodology called name and shame.
Yes.
Together with other things, obviously.
Yes.
I've seen in your report in particular, there are a lot of sections that are redacted.
Yes.
Are those reductions because you were trying to protect identities, or because there was not really a verdict of guilt there to be associated, but it was just fact-finding? Explain to me why there are so many reductions in the text.
Yes. Initially, when the Attorney General appointed our Commission of Inquiry, he put as a condition that our report would not be published without the authority of the Attorney General. The Commission of Inquiry thought that it was very important that the report would be published for obvious reasons, but the Attorney General still thought that he should have the right to delete names of people if he considered it in the public interest. Our Commission of Inquiry agreed with the Attorney General because the Attorney General, at the end of the day, protects the public interest, is the protector of the public interest. Therefore, he had the right to delete if he thought it was in the public interest. And of course, there is the law for the protection of personal data that had also to be complied with. So whatever you saw in our report deleted was either for the protection of personal data in accordance with the relevant law, or they were deleted because the Attorney General considered it in the public interest to delete.
Since this was an advisory report for the Attorney General, why was it published in the first place?
The Commission of Inquiry thought that it shouldn't be only for the use of the Attorney General, but it was a very big issue of interest to the public at large. And
was it a public relations exercise?
No, it was not a public relations, but it was a way of giving information to the public about what went wrong with this plan.
Looking at more generally the problem of corruption in Cyprus,
yes.
What would you like to see happen over the next few years?
Yes.
That we can finally get a hold of this problem
yes.
in hand?
Yes, there are actually a few things that I would like to welcome. The first one is the establishment of an independent authority against corruption. The law was passed very recently, and the President of the Republic has appointed President and members of this authority. This authority will not have prosecutorial powers, but it will have powers to investigate and report to the Attorney General after complaints that will be filed with this independent authority. So I think this, in combination with the law that gave protection to the whistleblowers, will permit whistleblowers to complain to the independent authority against corruption and report cases of corruption. I hope that this independent authority will play an important role in the fight against corruption. The other thing is that recently it was appointed a Cypriot prosecutor at the office of the European prosecutor in Luxembourg, I think. And this European prosecutor has the power to prosecute cases of infringement of European Union law by Cypriot citizens or residents of Cyprus. So this is another possibility of bringing prosecutions against corruption with respect to Cyprus. And of course, I would like the law office of the Republic, the Attorney General to as it is doing its best, to continue doing its best in order to fight corruption.
What about the speed or the tardiness of the administration of justice system in Cyprus? Do you think that has an effect?
Yeah, the administration of justice in Cyprus has problems, has merits, but it has also problems. I would say the merits of our administration of justice system is the independence of the judiciary. Nobody can intervene with the judicial task of a judge. And I would say that the responsible body is the Supreme Court for the judges and not the Minister of Justice, as is the case in other European and other countries. So I would praise our judiciary for its independence. I would also say that, in my opinion, the level of the administration of justice is satisfactory. The main problem, which of course is a major problem, are the delays. And we have delays mainly in civil and administrative cases, first instance and on appeal, but not so much in criminal cases. The criminal cases are tried within 1 or 2 years, I would say, and this is quite satisfactory, in my opinion. It could have been better, but it's quite satisfactory. But with civil and administrative cases, we have delays of over 5 years, unfortunately, at first instance, and another over 5 years on appeal. As you know, there are bills for the creation of a new Court of Appeal with 16 members. And if the new Court of Appeal is established, I think this will improve the situation of the hearings of civil and administrative appeals. And of course, if the Supreme Court is divided into Supreme Constitutional Court and High Court, as it was the case in accordance with our Constitution of 1960. In my opinion, this will also improve the situation, because the unified Supreme Court we have today, and it is unified since 1964, after the Turkish Cypriot judges withdrew from the judiciary. The unified Supreme Court has a load of work, both on constitutional and administrative matters, and on civil and criminal matters. In my opinion, it would be better if the Supreme Court was divided into two. The judges of the one Supreme Court could also have disciplinary control over the judges of the other Supreme Court. And of course, the 16-member Court of Appeal, in my opinion, is necessary to be established as soon as possible.
Judge, a final point, just to clarify how the Cyprus Supreme Court really functions in the Constitution.
Yes.
Is it much like the United States Supreme Court, where there is a judicial review of all legislation and so on, or is this more, I know that there is a division of powers between the various sections of government, but where does the Supreme Court stand? Is it is it the final arbiter, or?
Yes.
Not?
Yes, I would say that it has similarities with the Supreme Court of the United States. It has full power to review the constitutionality of laws or of administrative acts. If the Supreme Court decides that a law or a particular section of a law or an administrative act is unconstitutional, then this particular section or particular law cannot be applied in any other case. But of course, it is up to Parliament to amend the law or to change the law in accordance with the decision of the Supreme Court. It has full power, the Supreme Court, to declare any law or any act unconstitutional that is in contravention of the articles of the Constitution or of the fundamental principles of the Constitution. The principle of separation of powers is a fundamental principle, and many pieces of legislation are declared null and void, unconstitutional, that is, on account of the infringement of the principle, of the cardinal principle of separation of powers.
Yeah. I think the U.S. Supreme Court has gone a step further. It interprets the Constitution also. I'm not sure that the Cyprus Supreme Court has the power to interpret the Constitution. It's two different constitutions. In the U.S., it's very sparsely stated. In Cyprus, the Constitution is very long and very extensive and consists. It's almost a book. So does this affect the power of the Supreme Court?
The power of the Supreme Court includes the interpretation of the Constitution, and many times it is called by, if there is a conflict of power between, for example, the executive and the legislative powers, they can apply to the Supreme Court to decide who has the power to do something in accordance with the Constitution. So I would say, yes, it has the power to interpret. Of course, it does not have the power to amend or change the Constitution. For this, it is the legislative power, and it is with the majority of 2/3 that they have to decide to change the Constitution, and this also on the basis of the law of necessity, because since the Turkish Cypriot members of parliament are not there since 1964, every amendment of the Constitution is done on the basis of the law of necessity, in order, that is, for the state to survive.
Does the practice of necessity also cover, because there are certain constitutional provisions in the Cyprus Constitution which cannot be revised according to the Constitution?
They are what? Sorry?
They cannot be altered.
Yes.
Does the rule of necessity also cover those or not?
It has never been, the law of necessity has never been utilized in order to amend these fundamental articles that they are unchangeable. It remains to be seen what the judgment of the Supreme Court will be if such an issue comes before the Supreme Court. Because we had about 20 amendments of the Constitution in the last 60 or so years, but no fundamental and unchangeable article of the Constitution was amended on the basis of the law of necessity.
Judge, thank you very much. I think we've covered quite a broad spectrum, starting and relying on your extensive expertise. We thank you very much for your time.